Convicted killer Janusz Walus has been deported to Poland after completing his parole. Now, Walus was convicted of the 1993 murder of anti-apartheid activist and South African Communist Party leader Chris Hani. He was sentenced to death, but his sentence was commuted to life in prison. Justice Minister Mamoloko Kubaya has confirmed that the Hani family and the SACP have requested for an inquest into the matter. Let's discuss these developments now with human rights lawyer Gina Snyman, who joins us virtually. Good morning, Gina. Welcome to Newzroom Afrika.
Good morning, Mr. Chava.
Firstly, is South Africa's outrage justified?
I think we should take a couple of steps back before we can jump into that question. And I think the critical point to recognize here in the question of whether justice has been served and whether outrage is justified is that it's been recognized as a crime against humanity what apartheid was and what it took from the majority of South Africans. And added to that, the assassination of Chris Hani and what that meant for his family, his comrades, and what could have been for a country could never be properly compensated. That said, though, Janusz Walus was prosecuted, he was convicted, he was sentenced, and he served a sentence. So in terms of criminal accountability for the crime that he committed, he has served his sentence, and the consequence of that for a person who is a foreign national without another claim to remain in South Africa is that he would be facing deportation. That is the running of the course of the law. And there is nothing incorrect with that process or procedure.
All right, let's expand a little bit more on that process and procedure. I mean, were the processes and procedures followed by the Constitutional Court from sentencing all the way through to parole, were they adequate and were they fair? And how so in the case of Janusz Walus?
So in the case of Janusz Walus, what we have in fact seen with previous iterations and successive political leadership within the Department of Justice and Correctional Services, if there was any unfairness in the processing of Walus's conviction, sentence, parole decision, and decisions around deportation, the unfairness has not been in the content of how South Africans have received a disservice because of additional treatment for him. What we have seen is that in attempts to ensure that Walus would never be able to receive parole, various policy decisions were made within the Department of Justice, which had the consequence that thousands of other prisoners within South African prisons were unable to access the parole process that they were entitled to receive. And these are non-political prisoners who hadn't assassinated Chris Hani and who had served the time that they were required to before being able to apply for parole, whose decisions were never considered or processed in all of the iterations and policy shifting that was intended to keep Walus in prison. So in terms of processes that were not followed, I would say that there were, but they weren't in favor of Walus. They were to the detriment of upholding the rule of law and the constitutional rights of thousands of other prisoners whose parole, where the parole system was skewed in furtherance of trying to ensure that Walus remained in prison.
All right.
In terms of the Constitutional Court's decision that ultimately found and set aside various decisions of parole boards to refuse to grant, and various decisions of the minister to refuse to grant Walus parole, the Constitutional Court upheld the principles of the rule of law, that once a person has served the sentence, and in fact Walus served longer than his initial sentence from the court that convicted him, that a person is then entitled to release.
I think many people would definitely disagree with you, Gina, starting with the fact that the family and the SACP are saying, firstly, there was no full disclosure about the assassination of Chris Hani. That's the first thing. I mean, does the decision to grant parole to Walus not undermine the principles of A, accountability, and B, transparency?
So where this differs in the decision around Walus's parole is that because of the period that he had served in prison, by the time there was eventually a decision for his release after many court applications that he brought, is that he had already served longer than his sentence would have been. Normally, in terms of parole application decisions, these are factors that would be taken into account. But in terms of someone having served their full sentence upon a conviction and then being entitled to release, then it is not a factor for determination of whether there has been full disclosure of the crimes that were committed. And what is really important to distinguish here is that Walus is someone who committed of the most heinous human rights atrocities against Steve Biko, against Chris Hani and his family and South Africa. That is not at all in dispute. But he was prosecuted and convicted and served a sentence. What I think is important not to lose sight of here, and in the conversation around the conclusion of his parole and his deportation, is that in the context of unprosecuted apartheid-era crimes, there are still scores of families of victims from apartheid-era gross human rights violations that have not had their matters of their loved ones investigated or prosecuted. There are matters where, at the conclusion of the Truth and Reconciliation process, where those perpetrators either did not apply for amnesty or were refused amnesty, that were handed over from the TLC to the National Prosecuting Authority, that have never been investigated or prosecuted. So while there is a re-attention and focus on apartheid-era crimes, it is also important that there are scores of other perpetrators that have never faced any criminal accountability. And that is a focus area of where government could be putting its attention to ensure that there is justice that is done for apartheid-era crimes.
Yeah, let's take a step back here, Gina. I heard you say earlier that, as a matter of fact, Walus served a longer sentence than what he was supposed to. Walus was initially sentenced to death, but that was commuted to a life sentence. Couldn't he have been one of the last to be executed before? I mean, he literally, the nation is saying that he got away with murder.
He, like many people that have committed murder or assassination, was prosecuted, convicted, and served a sentence. South Africa made the decision as a country, and it did so through a constitutional court decision as a constitutional democracy, to do away with the death penalty. And that is a decision that remains and is constitutionally sound. That he didn't receive the death penalty because that was a decision that was commuted after the death penalty was abolished, is also applicable to many other political prisoners. So that is not a situation of him having gotten away with murder. It is a situation of Walus having received the same outcomes of law, which is a requirement of rule of law, that it is applicable to everyone, that is provided for in terms of our legislation and constitution.
What implications would you say his parole held for the legacy of truth and reconciliation, the TRC in particular, and the pursuit of restorative justice in South Africa?
In terms of the restorative justice process in South Africa, resolving, if it's possible to resolve the outcomes of the TRC process, the focus on Walus as an aspect of this is because it is so incredibly painful for South Africa's past and his family and comrades and everyone involved. And this is not at all disputed, nor could it ever be. There are still thousands of people seeking reparations that they would have been entitled to from the finalization of the TRC process. And there are still scores of people that are seeking criminal accountability that have not yet received it for their loved ones. So in terms of reconciliation, restoration, and truth-seeking, this is a project that still needs to be very much ongoing in this country. But it cannot be used as a mechanism to keep Walus in South Africa, where there is no other basis in terms of immigration legislation for him to be in this country. It is a standard process and commonly applied that where foreign nationals who have completed their sentence or completed their parole face deportation if there's no other basis for them to apply for asylum, apply for any other immigration status in the country. It is a normal process that they would then face deportation.
Judging by the commentary, well, polarized as they may be around not only the parole but the deportation of Walus, can you comment on the potential implications of deporting someone who may still pose a risk to public safety? I mean, as we've rightfully said, he committed a heinous crime.
Decisions around whether or not someone may be a risk to public safety are, of course, factors. They're factors in decisions on the receiving country. Those would be factors for determination for the Polish government to make a determination on. Deportation is a bilateral act from South Africa conducting the deportation to the country of origin, then receiving the person back. Those are factors for consideration that the Polish government in receiving Walus back must take into account. If there are concerns that Walus poses a risk to public safety, then those are decisions for the Polish government to take into account on his return in Poland. Those wouldn't be determinants for him to remain in South Africa. If he is a risk to public safety, there would need to be a basis in law in which he could be removed from society or detained. And that does not exist in this present case because his sentence has been served.
All right.
Unless there is a further charge on which he could be prosecuted, and that would justify a detention on the basis of a conviction, this is no basis either on which to block a deportation.
Before I let you go, Gina, lastly, the Hani family, as well as the SACP, are requesting an inquest into this matter. They are citing that there are many things that were not taken into consideration. What are your thoughts on this?
I think that it is well within their remit to use all avenues of legal process for the relief and the remedy that they're seeking. And where there are bases for them to seek and have an inquest opened so that they can understand more of what happened and obtain the truth that they're seeking. I wish them all the best in this endeavor and that they should use every avenue of the law available to them.